Thank you, Mr. Chairman. So, Professor Bray, I'm going to ask you to stick with me for a second here and talk about possibilities. Along comes President Trump and decides that the following sentence doesn't make sense. 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So the president decides one of his 103 executive orders will eliminate that language, the language of the Constitution, and question whether or not birthright citizenship is legal in America. Cases were filed. One judge, a Ronald Reagan appointee, said the efforts by the administration are blatantly unconstitutional. If you accept the normal process which you described to us, how should that case be handled if we've done away with the universal application of decisions?
Thank you, Ranking Member Durbin. I think that's an excellent example of how the courts are supposed to work. The courts are going to decide the cases. In every single one, the courts will say there's birthright citizenship under the Constitution. There will not actually even be a disagreement between the circuit courts, and there won't even need to be a decision from the Supreme Court. So what you'll see is distributed decision-making across the federal judiciary that will resolve the question.
But assume the alternative, that there is a federal judge in some state, I'll pick one, Texas or Louisiana, who says, I think the president's right. I believe birthright citizenship is unconstitutional. So you have a case in controversy, and it affects only the cases filed in that district?
Well, it wouldn't affect just the cases filed in the district, because a district court judge actually has no precedential authority, even within a district. There's no ability for a district judge to.
Well, let me amend my comment. Circuit.
Yes, if a district judge took that position, and then it was affirmed by the Court of Appeals, then what you would have is a circuit split between different circuits, and the Supreme Court would resolve that circuit split. And then what the Supreme Court would have is a range of different judges from different geographical places with different ideologies, different generations, all speaking to the same question, and that puts the Supreme Court in a position to do its best work. I don't think that particular legal question needs to be in doubt, but just because one branch goes beyond its constitutional bounds doesn't mean the judiciary should go beyond its.
So I guess my question is, in light of individuals personally affected by this, pregnant women as an example, we just have to let the process play out? Is that what you suggest?
There are ways to get a faster decision. As Professor Vladeck noted, you could have a national class action. But I think the basic commitment, I recognize there can be a human cost there, but the basic commitment of our legal system is you don't get an immediate right decision right away. It takes time. It's like the old carpentry adage, measure twice, cut once. And that's the kind of legal system we have.
Professor Vladeck?
I mean, I think it's worth underscoring the human consequences that my friend just kind of brushed right past. Because if it takes 3 years for that circuit split to get to the Supreme Court, you're going to have 3 years where in large parts of the country, children born to undocumented parents will not be citizens. Some of those children could be subject to removal by the United States on the ground that they are not citizens. It is not possible for the federal courts to order those folks to be brought back. And so that relief that Professor Bray holds out as possible 3 years later is of no help to the children who were citizens under the Constitution, but who were removed in the interim. And so again, I mean, the broader policy question here is what should the rule be in this interim window? Professor Bray and I agree that it's all about what is the status quo while the case gets to the Supreme Court. Should the status quo be the policy is either in effect or not in effect on a nationwide basis, or should the status quo depend upon which jurisdiction you live in and what your particular status is? And that's why it seems to me if we want to talk about real reform, we should be talking about reforms to bolster the other vehicles, the nationwide class action, and not just taking off this stopgap that has emerged in its place.
Thank you.
Thank you.